Did you know that more than 60% of Americans don't have a will? This means that more than half of us risk having our hard-earned assets distributed by state laws rather than by our own wishes. It's like taking decades to build a beautiful home and then handing the keys over to a stranger who decides who gets to live there. If you're approaching retirement and you haven't taken the time to update your estate plan recently, you could be missing critical points of protection which could end up costing your family unnecessary costs or taxes down the road. Stick with me today as we're going to cover some of the crucial points that we cover during our estate planning reviews, which we commonly see missing when we meet with clients for the first time. Before I do jump into that, if you find our videos helpful and educational, please take a minute to like and subscribe to our page. Most people nowadays think they might have their estate planning covered by a simple will. But let me share something shocking with you. According to caring.com, while 33% of people might have a will completed, about 80% of people are missing at least one crucial piece of their estate planning documentation. This gap creates what I consider to be a protection illusion, where one might feel a sense of security, but one's family might be vulnerable emotionally and financially down the road due to inadequate protections in place. Let me illustrate this for you with a hypothetical family that unfortunately had to learn this out the hard way. John and Martha had recently retired at the age of 62. They had a modest nest egg, they had their home fully paid off, and they had a simple will completed recently by an attorney. A common phrase we might hear in a situation like this during our client meetings is, "We've got this covered." Although a will might outline assets set to be inherited at some point, what many don't realize is that will does not take effect until death, potentially leaving one vulnerable during a time of incapacitation. Unfortunately, sometimes in life, unexpected things occur. And in this situation, John ended up suffering a stroke months later. When Martha tried to access their accounts to pay for specialized care needed by John, she hit an unfortunate roadblock. And at this point in time, she realized that all of their accounts were only in John's name. Despite being John's spouse, not having the right documentation in place left Martha completely powerless. What followed was a nightmare of legal proceedings during a time where Martha was already under duress due to John's condition. At this point, Martha learned that she had to petition to be John's guardian and conservator, a process that ended up taking months of time and thousands of dollars in fees. As bills mounted, investment opportunities diminished, and Martha spent sleepless nights worrying about legal proceedings in addition to having to worry about her husband's care. The court eventually approved Martha as financial conservator, but the mental damage had already been done. The protection that John and Martha did not have in place at this time comes from two key incapacitation tools. The first being a healthcare proxy or medical power of attorney, and the second being a financial power of attorney. Each of these documents are examples where you allow somebody that you trust to take care of you first in a healthcare setting, and second in a financial setting if you are not able to do so yourself. These statistics about incomplete protection aren't just concerning. They can actually end up being devastating to one's heirs. While you might think your estate plan has you covered, a significant change to legislation took place years back, which completely changed the game as far as retirement accounts are concerned. In 2019, Congress passed the Secure Act. And among other things, this act did change the way that retirement account inheritance works. If your estate planning hasn't been updated since then, unfortunately, a hunk of your hard-earned savings could end up in the hands of the IRS as opposed to the hands of your loved ones. It's important to note that this type of planning requires regular ongoing maintenance, as over time, laws might change, as well as the variables in one's life. In this instance, the Secure Act eliminated the stretch rule, where at one point you were able to take out required minimum distributions from inherited accounts over the course of your lifetime. And now you have to empty those accounts out over the course of 10 years. This accelerated timeline could potentially push your heirs into a higher tax bracket, which could end up forcing them to pay thousands of dollars in excess taxes. Being that this landscape is constantly changing, let's take a look at 5 critical documents as part of your estate plan and how they might pertain to you. First up on the list is the comprehensive will. Some might consider this the foundation to one's overall plan. Think of it as a blueprint when you're constructing your legacy. Your will can do things like help you distribute assets, help you designate guardianship for your children, or even distribute digital assets and other valuables to avoid family members getting into fights. The second item to consider is the Advanced Healthcare Directive or Living Will. This document will act as your voice in the event that you are unable to speak, and it'll outline your preferences for healthcare treatment. Without these instructions, family members might disagree on your healthcare preferences during a time which is already stressful and could unfortunately cause unnecessary conflict. Third up is the healthcare proxy, which will designate somebody that you trust to make healthcare decisions for you in the case you are unable to do so. This person ends up becoming your medical advocate, ensuring that your wishes are followed rather than defaulting to state-mandated policies. Selecting someone who understands your values when it comes to medical care is similar to selecting a navigator to be by your sides through choppy waters. The fourth tool to consider is a durable financial power of attorney, which allows the selected agent to handle your financial needs during a time of incapacity. This document acts like a financial safeguard, preventing accounts from being frozen and allow things like bill pay to continue going on while you are not able to do so yourself. Finally, consider the different type of trust accounts as well, and see if they might be appropriate for your specific situation. A properly structured trust can act similar to a protective container, preserving your assets and allowing them to be used to follow through in accordance with your wishes. Something like a standard revocable trust can help you avoid probate with your assets when passing them to the next generation. But there are also specialized trusts which could be geared towards different matters and goals as well. A few examples of specialized trusts could include something like a marital trust, which could be used when planning for estate taxes, a spendthrift trust, which could help to protect those who are financially irresponsible from financial and investment mismanagement, a special needs trust, which can help provide support for those who are disabled while being careful not to jeopardize government benefits, or a business trust, which can help facilitate succession planning or even potentially reduce tax liability. By reviewing these crucial documents and understanding how they might pertain to you, you can make sure all of your affairs are in order and focus on what really matters most. If you were to ask me what's preventing 2/3 of Americans from protecting their legacy, I'd say the answer probably lies in the myths convincing those same folks that they don't need planning at all. Let's use an example of our friend Sarah, a middle school teacher living a modest lifestyle in her suburban home. Sarah believed that estate planning is only for the ultra-wealthy, and someone in her position living a relatively simple life wouldn't benefit from having that planning done for her. When Sarah unexpectedly passed away at the young age of 58 years old, her children ended up finding out that she had an estate worth roughly $750,000, including her retirement accounts, her home, and her life insurance policies. Without having the proper planning and documentation in place, or the proper beneficiaries listed, unfortunately Sarah's estate went through a lengthy period of time in the courts over the course of 18 months. Her children ended up having to face mounting legal fees, tax uncertainties, and emotional strain having to deal with bureaucracy during a time where they were already grieving. Needless to say, this outcome is probably less than desirable for most. With that, we try to educate our clients about common myths when it comes to estate planning reviews during our meetings. These myths include the following. Myth number 1, I don't have enough money or assets to need an estate plan. Unfortunately, this common misconception can end up leading families of all different financial scenarios to complications which could potentially have been avoided had they done the planning properly. Myth number 2, my spouse will get everything when I'm gone automatically. Unfortunately, this might not be the case, and due to some state intestacy laws, assets could end up getting split between your spouse and other relatives. This could end up forcing a sale of illiquid assets in something like a home or a business, which could end up creating financial and tax complications down the road. Myth number 3, my family knows what I want. The reality of the fact of the matter is that studies show that even close family members only correctly predict healthcare preferences 65% of the time. This gap can lead to painful disagreements during already strenuous times. In some cases, this can end up leading to decisions being made which actually are against your real wishes. And myth number 4, estate planning is just too expensive. The reality here is that in some cases, having the proper documentation and planning put in place is less expensive when compared to the potential costs of probate, additional lawyers and fees, or unnecessary taxes for not planning properly. It's very important to note and to keep top of mind that your estate plan is very similar to your life, and in many cases, it is not just static. Over time, things change and laws evolve, and keeping on top of your planning could be beneficial. In addition to that, understanding when a good time to look at things is also important. Going through changes like marriage, divorce, birth, or death could all be reason to check your documentation. Estate planning reviews can help to bring peace of mind. Having a plan that is current and up to date and outlines your goals and values can help not only to alleviate anxiety, but also can help to empower you to feel that your legacy is properly laid out for the future. For more information on legacy planning, check out our next video here.